Good morning to everybody. This is Don Hall with the Virginia Automobile Dealers Association. Good morning, sincerely. Hope you're having an outstanding day and the beginning of the summer ahead of us. We're particularly excited to start this meeting today and to talk about some things that we think are of great importance for each and every one of you. We are recording this so you can go back and listen and be able to hear in the future in terms of what we've said and the comments we've made today, particularly. I am particularly pleased today to tell you that we've got our three lawyers that will be doing the bulk of the presentation. You'll hear from me at certain points, but by and large, I've asked the lawyers to sort of conduct and lead this, and all three have experience, obviously, and understand your business and what goes on day in and day out, and have been a big part of many of the issues in the last year that have gone on. We've got, of course, Ann with us, who's a staff attorney at VADA, Mimi, who's a staff attorney at VADA as well, and then Barrie, who is an outside counsel to the Virginia Auto Dealers Association, who has literally spent her entire life in the auto industry, working with and for a legend in our business for a long time, Mike Charapp. And so with that in mind, today we're going to be covering a number of issues. We'll do a little bit of a legislative update on what's going on. We've got dealer-related legislation that we'll talk about. These are things that do impact you as auto dealers and truck dealers throughout Virginia. Fortunately or unfortunately, a little bit of both, depends on how you look at it. We've got a lot of employer-related bills as well. And I'll talk to you all about that in just a minute, why we have so many of them, but we do. We have a number of consumer protection or consumer-related type bills also that I want to review today with you all as well. Under the legal update, we're going to be going into the FTC advertising compliance, the compliance issues in general, and franchise issues as well. So a number of issues we'll be talking about today that impact your business. Again, this meeting is for you. If you have comments, you can email them in. If we can get to them while we're talking, we'll do so, or at the very end of the presentation, or even after the fact. And depending upon the nature of the question, we may not bring it up publicly. We may come back to you later privately and then answer your question. Let me tell you about our legislative team for a minute, if I can. I think it's important to understand why and who and the changes. I've had the privilege of being at VADA for pushing almost 40 years, so a long time. And a lot of things have changed over the years, including the General Assembly quite a bit. So each year we try to do what we call a dealer day on the Hill. We ask that you all participate. I can't stress enough the importance of doing that. And I hope going forward that each of you will take advantage of it and be a part of it. Number one, you're taxpayers. Two, you each have senators and delegates back home that represent you. It's critical they understand who you are, what you are, and understand, not only your understanding of the business, but your love of our industry and the love of serving customers. On this, you'll see a list of people involved directly in our legislation and the VADA. Again, I've already told you about Ann Gambardella, Mimi Perka, Barrie Beaty. I've got Tim Polhanka is our legislative chairman, Polhanka Automotive Group. Roger Keller from the She Automotive Group is our current VADA chairman. We have the law firm of Gentry Locke, Greg Habib and his partners as a part of our legislative, and does some legal work also. Meet Spots with Spots Fame, legislative counsel as well to the VADA. Ralston King, the Commonwealth Strategy Group, he's an outside lobbyist for the VADA. And Trip Perrin with the Lindell Court, he's also an outside lobbyist with the VADA. We have, as I just indicated, we've actually added a number of teams. In fact, Ann, if you go back for just a second, at the very bottom, you'll see, we've got the Gentry Locke Group, the Spots Fame, Commonwealth Strategy, and the Lindell Corp. In the past, early in my career, for a lot of years, up until really the last couple of years, we never had that kind of team put together. The game has changed dramatically. In my, again, almost 40 years of having the privilege of serving you all, I've watched the numbers and the turnover take place massively. And let me give you an example. Take just a minute, kind of follow along with me if you would, and look at that chart above. The Democrats hold all three statewide offices. Democrats, that's governor, lieutenant governor, attorney general. Democrats hold 64 of the 100 House seats. They gained 13 seats. The Democrats also control the Senate of Virginia as well. And for many of you that are wondering, and throughout my career, I've been in periods where Republicans had all the above and Democrats have had all the above. In fact, when I started here back in the 1980s, the Democrats were in control of everything. So this is not unfamiliar territory, but it means lots of people come and go. And the nature of public office today is they come and go. And I might, as a side comment, just remind you, these folks that you hear about and you hear us talk about, and that we every year ask you to come to Richmond to be a part of, they're making on average in salary as a member of the House or Senate about $18,000 a year. And so we're not talking big money. These folks have a love of wanting to serve. They typically have jobs back home, and some don't do well financially because of the commitment. But I did a little bit of math for just a minute for fun, if you will. Our sessions on even years are 60 days. They're 45 days on odd years. So in 2 years' time, that's 105 days they've actually been in session and worked. In 4 years, that's another 105 days for a total of 210 days. That's about 7 months. So look at what we have up on the chart. 4 years, 60% of the legislators have served about 7 months in total. Now, some of them have some committees that will have assignments throughout the year. But in terms of being in session, in terms of we having access to them, truly having access to them, and the lobbying days and so forth, you're talking 7 months in 4 years' time. This game moves very rapidly. Things happen where legislators go, oh my God, I can't believe we passed this bill. We're going to have to address it in 2027. We have some of those. Again, just to finish up the chart, 5 to 12 years, 24 members, 24% of that, 13 to 20, 11 members, 11%, more than 20 years, 5 members. Again, I predate everybody in the House and Senate. Nobody in the House and Senate was around when I started at VADA long ago. And so the world has changed rapidly, which is why we have you involved, which is why you've got to be involved with us. It's critical because the turnover is so rapid these days that we cannot do it alone. Our team has grown for that reason as well. As part of that turnover, you have new governors come in, they make changes. Sandy Jack is our new commissioner of the DMV. Frankly, I've not met her yet. She is busy getting her arms around this large agency, the DMV, and that's kept her extraordinarily busy. She's a lawyer by education. She's got 20 plus years in public service. For those of you that would care or have alumni of universities, she's a graduate of the University of Virginia, and she has a law degree from William & Mary, which is where our counsel, and Gambardella also has a law degree from as well. In fact, I think they were in law school about the same time, approximately. So I don't know Sandy. I know of her. She's got a good reputation, hardworking. We have some meetings set up with her. For those of you that are coming to the convention, she will be there for a portion of it as well. Next is Kelly Smith. Kelly is the new executive director for the Motor Vehicle Dealer Board. To remind each of you, that is the board that regulates your daily practice, your advertising, licensing of salespeople, unlicensing, ad violations, fines against salespeople, claims against the recovery fund. She's in charge of all of that. She too has a pretty lengthy resume with being involved in public service and working around boards. She was hired in fact, some of our dealers were involved in that hiring process as well. She also is a graduate of VCU and then has her law degree from the same university that Mimi went to, University of Richmond Law School. So we have our two lawyers, each have a connection, if you will, to these women as well, as they both went to their law schools. And so both of them are brand new. There's a lot to learn. We have a lot of new legislators. The game is at fast speed. It reminds me of being a young man in the car business so very long ago, where Saturdays were crazy, selling lots of cars, busy, busy, busy. The world has changed a lot since then, but in the legislature, it's changed to being very busy with massive turnover. And so we are on top of it, but I don't want to be anything other than direct with you, and that is we need you to be involved as well, because you may have connections through UVA or William and Mary or something else where you might know Sandy Jack or Kelly Smith, and that matters and it makes a difference. Plus, you have great stories to share as well. At this time, I'm going to turn it over to Mimi, who is our chief lobbyist now, and she will tell you what she's done and what's going on. Though, as you would expect, I've been down to the General Assembly, and Ann is with her as well. But Mimi has the distinction of kind of leading the way now for the lobbying efforts at the Virginia Auto Association. Mimi, it's you.
Thanks, Don. We're going to get into some legislative updates, and I'm going to start with the bills that directly impact dealership operations. First, a dealer record bill. This bill modernizes how dealers can maintain their records. Previously, dealers needed prior approval from the dealer board to store and preserve records electronically. You no longer need to get this approval. Next, a bill dealing with dealer business hours filing. So if your business hours change, you file that update with the Motor Vehicle Dealer Board, not the DMV. This bill is almost a fun fact because, funny enough, the code section had been pointing to the wrong agency since the dealer board was created back in the 1980s. Next, a bill on dealer plate use expansion. There's been an expansion on what dealer plates can be used for. Previously, dealer plates could not be used on a vehicle transporting vehicle parts, accessories, small amounts of fuels, or taking trip to automotive supply retailers. This bill removed that prohibition, so dealer plates can now be used in those situations. Again, this is a practical change. There's also been a bill that deals with the Motor Vehicle Transaction Recovery Fund. For those of you who may not know, the dealer board operates a fund called the Motor Vehicle Transaction Recovery Fund, which pays judgments out to consumers who have been harmed by a licensed Virginia motor vehicle dealer when the dealer is unable to pay the judgment. This bill expanded when consumers can be paid out, and it now includes a provision to pay consumers who suffered a breach of an extended service contract from a licensed dealer. There was a potential fiscal impact of this bill that raised some eyebrows during the legislative process, so we worked to have this bill amended to provide some guardrails and to protect the solvency of the fund long term. You'll also be glad to hear that there is a bill this year that extended the license plate use for loaner vehicles. So under current law, when a customer uses their own license plates on a dealership loaner vehicle, that was only allowed for up to 5 days at a time. 2 bills passed this year that will extend the allowable window to 30 days, along with that corresponding permit. We're hoping that this is an improved option for service departments dealing with lengthy service repairs. Next, there was a bill this year that passed on glass repair and ADAS disclosure. As you all know, as vehicles have become more technologically sophisticated, glass repair has been a much bigger deal. A bill passed this year which will require glass repair facilities to let customers know when their vehicle has advanced driver assistance facilities and whether the shop is actually equipped to recalibrate those systems after repair. If not, the customer will be sent to a dealership. The final version.
Just 1 second. Mimi, is there a, are you on the actual Zoom or are you just on the presentation?
I'm on the presentation.
Yeah, make sure your Zoom is off because we're hearing there's an echo. So the
Give it
presentation should be fine.
Oh, sorry.
Yep, that's fine. Let's just close out the presentation. Yeah. Sorry, folks. We got a chat that there was a.
My bad. Okay, sorry. Continuing on. So this bill passed that will require glass repair facilities to let consumers know whether their vehicle has advanced driver assistance systems and whether the shop is equipped to recalibrate those systems after repairing the glass. If not, the customer will be sent to the dealership. The final version of the bill also included a provision which will allow for an emissions inspection waiver for those of you who have to do emissions inspections. If the vehicle failed the inspection and is in the onboard diagnostic system is in a not ready condition to be tested when the vehicle is presented for reinspection. So now you can get a waiver in those circumstances where you couldn't before. There was also a bill for gap insurance and waivers, which have been long sold in Virginia for years, but there was ambiguity in the law actually about whether they were authorized. The bill cleared it up and it explicitly confirms that both gap insurance and gap waivers are permissible under Virginia law. We also had a bill passed this year that dealt with modification of loss estimates. This doesn't squarely land on dealers, but it will impact insurance and body shops. So this is a new law that prohibits public insurance adjusters from changing an estimate of loss unless they provide a detailed written explanation for each modification. This is intended to bring more transparency and accountability to the claims process. Should help auto body shops push back when adjusters make unexplained changes to repair estimates. Then we're going to transition to some employer-related bills. First, I'd like to talk about minimum wage. So there was a lot of movement in the employment arena during the 2025 legislative session. So this is a good time to pay attention. I think Anne's trying to get the slides matched.
Yeah, I think
here.
the slide is correct.
Okay. So let's start with minimum wage. Virginia's minimum wage is going up. Here's the timeline. Right now, the minimum wage is $12.77 an hour. It's going to increase to $15 an hour by January 1st, 2028. And then it's going to automatically adjust each year based on the consumer price index. So this is not just a one-time change, but it's going to be ongoing. Next, this is important because this bill goes into effect July 1st, 2026. So that's next month. I want to make sure that everyone understands two main requirements of this bill. First, pay transparency in job postings. So when you post a position, whether it's internal or external, you're required to include the salary or compensation range for that role now. It has to be a good faith range, not just a placeholder. The law covers job postings, promotions, transfers, other employment opportunities. If an employee or applicant believes you are not complying with the posting requirement, they must first notify you or give you 15 days to fix it before they can take any legal action. Second, you cannot ask about a candidate's salary history. You can't ask what someone earned in a previous job, and you cannot use that information even indirectly when making hiring or compensation decisions. The exception is if the candidate voluntarily brings up their salary history. If they do that on their own, you can confirm the information and potentially use it to offer a higher salary. The key word here is voluntarily. You cannot prompt any candidate to give you their wage history. Both these requirements go into effect July 1st, 2026, so you should be reviewing job postings and interview processes now.
Let me comment on that for a quick second. Having been around this business for a very long time, it's typical to try to figure out what people are making in their previous job. And we may ask it not indirectly or indirectly rather than directly. Again, the law is very, very clear. There are penalties involved. This is a bit of a change to an industry that's kind of done whatever it's wanted to do forever. And we ask all kinds of questions we probably ought not to be asking to begin with, to be honest with you. So be mindful of the fact, I can't say, well, what did you make of the previous dealership you were at? It might be innocent and seem fun to say, yeah, no problem. You legally cannot ask these kind of questions. The world has changed. Elections have consequences and you have to abide by it. So this will be a change internally. And you've got to make sure that you talk about it so that the managers don't make the mistake of saying, well, tell me what you made at your previous job as an F&I manager. I need to have a feel for that before I can talk to you about what we would offer here at our ABC dealership.
I wanted to point out that VADA is partnered with Sesco Management Consultants, and they specialize in HR management and labor relations. They put together some specific guidance on a couple of these employment-related bills, and this is one of them. I'm not going to go through it too much, but it's recommended to go ahead and do an audit on your hiring practices right now. Definitely look at your application forms, your interview questions, and any other materials you might be using in the hiring process. If you're using the Sesco materials, they have already updated their standard application. So make sure that if you're using that, you're on the most current version, and then you should be good to go. You should be training up everyone who conducts interviews on this. Anyone who participates in hiring needs to understand what they can and cannot ask. I know we usually dissuade disclaimers here on this webinar, but you can consider adding a disclaimer to your job postings or websites acknowledging this ban on salary history inquiries and your commitment to compliance here. Next, the definition of wages have changed. And this is effective also July 1st, 2026. So a bill passed that codified an expanded definition of wages, and this is for the purposes of wage non-payment litigation. So this change is extremely relevant for dealerships because under the new definition, wages includes not just hourly pay and salaries, but also commissions, tips, bonuses, piece rate wages, overtime wages, and legally required prevailing wages. This overturned some recent Virginia case law for those lawyers following along, so this is definitely an update. The bottom line here is that once a commission is earned in Virginia, it must be paid, period. It doesn't matter if you have a policy that claws back commissions or if the employee left before the commission was paid out. If the commission was earned, period, Virginia law requires that to be paid. For dealerships that pay sales commissions, F&I commissions, service advisor commissions, you should definitely take a look at this and revise any pay plans accordingly. Our partners at Sesco also provide some guidance on this. The most important takeaway is that every pay plan needs to be in writing, signed, and dated. If you have informal or loosely defined pay plans, especially for sales or finance staff, you should have them documented. The second major point here is about overtime. Virginia law requires that overtime be calculated on all non-discretionary bonuses, commissions, and incentives. This is also a federal requirement under the FLSA, and Sesco notes that it is the #1 wage hour compliance issues for employers across the United States. It's important also to note here that your payroll provider is not the one responsible for ensuring this is done correctly. The compliance obligation falls on you as the employer. If you have any doubts about whether your pay plans are compliant, you can reach out to us and we'll get you connected with Sesco to help with any audit you might want to do.
Maybe one thing worthy of telling everyone today on this call, Sesco has been a partner of ours actually since the 1970s. This is all they do for a living. Many of you use them. Their fees are very reasonable and they're very good at what they do. And this is all that they do. And so again, most of you have probably by now heard of them because they've been around literally since the 1970s as a partner with the Virginia Automobile Dealers Association. So please, 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 we don't normally get into this area that much in what we do at VADA. And that's why we have Sesco. And we know there's a lot of changes this year, changes that frankly, in some cases probably were warranted. Some cases we would love to have stopped, but the momentum and the change and who got elected caused these things to take place. And we are where we are.
Okay, another employment bill, non-compete agreements. So Virginia's law on non-competes is also changing, and these new restrictions apply to agreements entered into, amended, or renewed after July 1st, 2026. So next month. As some background here, Virginia already restricts non-competes for low-wage workers and any non-exempt employee under the FLSA. However, as of July 1st, 2026, employers will not be able to enforce a non-compete against an employee who was terminated without being offered severance. So if you let someone go without offering severance, you will lose your ability to enforce the non-compete against them. Sesco also has recommendations on this. If you have non-compete agreements in place, you need to have them reviewed for compliance with this new law. Sesco can help assist with that. It's also too important to note that this new law does not affect non-disclosure agreements or non-solicitation agreements. Those remain valid and enforceable. But your severance agreements will need to be updated to align with new non-compete rules. If you've been using a standard severance template, it will need to be freshened up.
Mimi, can I just make a point on this?
Yeah.
Non-competes in general are not favored by courts. And you definitely should have your agreements looked at to be narrowly tailored in general. Like even aside from what the law changes are in the state of Virginia, they should be very, very narrowly tailored. And I suggest other types of agreements such as the non-disclosure, confidentiality, and non-solicitation. And if you are, let's say you've paid for a tech to go to school and it's based on him staying with you for a certain number of years, there may be narrowly tailored to do a repayment if he leaves before that certain number of years or something of that nature, but definitely have non-competes looked at.
One more employer-related bill that I want to cover here. And this is a bill that just makes some progress on initiating a heat safety standard in Virginia. So a bill passed this year, which is going to require Virginia's safety and health code boards to develop and adopt formal heat illness regulations by May 1st, 2028. So we still have 2 years, almost a little less than 2 years until we're really going to have formal regulations in this space. But as we know now, it's going to apply to both indoor and outdoor workers. So it's not just going to be a concern for lot attendants or detail staff. It's going to apply also to service technicians working in shops that maybe aren't always climate control. When the regulations are finalized, it's going to have requirements for water, access to shade or climate controlled spaces, rest periods, and required training on heat illness prevention. Since you have some time before these regulations go into effect, it's a good time to start thinking about if your facilities don't already have strong heat safety practices, or if you don't have great climate control in your dealership. It's a good time to start thinking about these regulations that are going to come into place in the next few years here.
Thanks, Mimi. I'm going to take over and talk about some additional employer-related bills. You know, Don went into some depth about the changes at the General Assembly, and these next several slides are, you know, part and parcel of the results of those changes. These are the ones you may have seen or heard about on the news. We're not going to spend a lot of time talking about how you comply with all of these because, quite frankly, the programs have not been stood up yet. There's lots of changes and lots of implementation and rulemaking that needs to go on before these are effective. But we want to put them on your radar just so you can be aware of where the state is headed when we talk about some of these employment issues that can, quite frankly, cost you some money. And we want to make sure that you're planning for these things to be available. Again, the first one you may have heard about, paid family medical leave. What the state is going to do is create a program for state administered paid family medical leave. It'll be done through payroll deductions for both employers and employees who will contribute. But as you can see, the contributions to that fund won't begin until April 1st of 2028. What that means logistically is that they're going to put the program in place by October of 2027 and not take anyone's money till April 1st of 2028. That means they're going to have 2 sessions to work on this before anybody has to pay anything. So again, that it's a bit out in the future, but we wanted to make sure that you had this on your radar screen. It's going to provide for some benefits up to 80% of the average weekly wage of the employee, but it's going to have a cap of 100% of the statewide average weekly wage. So there is some limit on that. And then it's also going to be something that employers are going to be able to quote unquote opt out of if you are providing those kind of benefits to your employees anyway. There's going to be a process to certify what you are already doing. So again, much to be many more details to come on all of this, but want to put this on your radar because it may be something that you see on the news, or quite frankly, your employees start to see on the news. The next issue is paid sick leave. Again, this is something that goes into effect a year from now for employers of at least 50 employees, and then, you know, ratchets down from there. But it's going to require 1 hour paid sick leave for every 30 hours. You know, you can accrue it or pay it up front. You have to be able to carry it over, and you don't have to pay folks for it when they leave. But again, more implementation details about this will be forthcoming with that July 1st, 2027 date. Wanted to make sure that that you saw that. Again, lots of this will be amended as we go along. For instance, I know that the governor made some significant amendments to the family medical leave as it went through. So I suspect we'll see some changes continuing to happen to these kinds of programs. There's actually a child care assistance program that is being implemented. It's actually going to be encoded. It'll be a matter of whether they provide any funding for it. This is a voluntary program, but in as much as you may provide uh, uh, if you provide any sort of child care assistance, there may be some state funds available for you to be able to apply for. Again, it's first come, first serve. More to come on that, as is the case with some of these programs that the state implements, not unlike the EV tax credit program that never got any money. This one may not end up getting any money, but can certainly be something that is worth watching if it's a program that you'd like to participate in and provide to your employees. And last but not least on the issue of legislation is class actions. So there was a pretty robust class action debate going on in Virginia for the last number of years. I know we've told you about this in a few other updates in years past. It passed the General Assembly. It was vetoed by the governor. They could not agree on some of the really important parts of this very critical legislative effort by the Democrats to bring Virginia into line with every other state except Mississippi that allows for state level class actions. There are federal class actions, but the federal courts are, a little more streamlined, a little more, there's certain rules about how things are done. And that's part of what this got gummed up on, not to be too much in the weeds, but the governor suggested some pretty important changes that were suggested by the business community that the General Assembly didn't particularly care for. So they rejected her amendments and she vetoed them. So again, just because you have a Democratic General Assembly and a Democratic governor doesn't mean they always agree on everything. But things like where the class actions could be filed, the governor wanted to limit it to Richmond, Roanoke, Fairfax, and Norfolk, whether there were statutory damages or actual damages, whether conduct before the effective date of the bill could still be part of a class action, some retroactivity. And then also for the legal wonky part of it, whether there's summary judgment in Virginia. And summary judgment, just sort of shorthand, is a way to dispose of cases a little more quickly and a little less expensively. It's something that's available in federal court. It has not heretofore been available in state court. So that was something that was a really important piece for the business community, as sort of a, not trade-off is the wrong word, but something that, a get we would get for the fact that class actions would now be part of Virginia code. And keep in mind that would mean that all Consumer Protection Act cases could be class actions. And so that it is not an insubstantial thing. And I suspect between now and next session, the General Assembly and the governor will get their heads together and this will become law next year if I had to bet.
Thank you, Mimi and Ann. They'll be back in a few minutes here. Let me talk about something that is never very popular to talk about at some level for sure, but understand clearly that we have to deal with the results of elections. We have a good PAC, but we don't have enough money to overcome certain types of elections. We play in the games. We help people out in order to have a relationship with them, and so we have some relationship. Money, I will tell you, after having been a registered lobbyist for 38 years, money does not buy votes. All it does is show that you care about them enough that they're going to spend some extra time wanting to hear your arguments, both for and against issues. And though this is a part of the program I never enjoy, because many of you will get, wow, Don, you got to ask for money. The answer is yes. And it's a time of year where we need to build our PAC back up, drive to 250. And so 250 years of freedom, if you will. And we want to add $250,000 to the PAC. And so, look, I'm reminded years ago, I was dealing with the Bankers Association, only to learn that in the Banking Association, all of the banks all encourage their senior managers to contribute to the State Bankers Association's PAC, Political Action Committee. You ought to be doing the same in the car business. One of my dearest, longest, closest friends in the world who has passed away, Karen Radley, had a philosophy that every manager that worked in an organization should give to the pack. And in her honor, you should be doing the same because it's the right thing to do. You can go online to make a contribution. Kid yourself not, money matters. You hear about California's elections that just took place. You've got New Jersey elections that just took place. There's big money playing in these elections. We as auto dealers have got to play. Trial lawyers have the largest pack in Virginia. Those are the individuals that sue you for a living. Those are the individuals that go after you for an array of reasons. They have the largest pack. We have to have a credible pack, credible size. So please, 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 we'll continue to be asking, give to the pack. Thank you on that message. Let me now get into the FTC and kind of just talk about things for a few minutes. 97 dealers got letters to include some Virginia dealers. Now, those were not 97 individual dealers. Some of them were very large publics, very large privates. There were some small ones too. It was a large group of dealers. The FTC put this out to get your attention. And thank goodness, many of you, it got your attention in Virginia, but there's more to come and more attention that has to be gotten. I have the honor and privilege of being invited on June the 16th up to Washington, D.C. You all have been invited. For many of you, this is just driving over, to Washington, to a particular hotel over there. CBT, who does these broadcasts nationwide, is the one conducting all this. Speaking in this panel, myself, for one, but also will be Senator Bernie Morano. Bernie is a longtime car dealer, immigrant with a large family from Cuba as a little boy, went on to be a very successful new car dealer in Ohio, knows the business. Coincidentally, I graduated from the NADA Dealer Academy recently, kind of a long story, but it was a lot of fun. And Bernie's son was my classmate. And Bernie and I met, and he said, "Gee, Don, I thought you'd be like my son's age." I said, "Bernie, I'm older than you, but I'm a guy who believes in education and a guy who believes in keeping up with things. And that includes what the FTC is doing." And so Bernie will be speaking as a U.S. Senator. It's very powerful to have him to be able to talk to the FTC and others. Brian Ben Stockwell will be speaking. Brian is, very well known if you're on LinkedIn at all. He's very, very good. David Kane, Paul Mitri from NADA, Scott Painter will be there. And happily, Barrie Beaty, our own lawyer, will be there as well. And so if you can be there, show up on the 16th in Washington, D.C. But it's all about what's going on at FTC. What are some of the things we need to do? With that in mind, let's kind of get into that. First of all, if you want to scan that, that'll give you a lot more information. We must make changes. Ladies and gentlemen, we must make changes. The way we sold cars and financed cars will not continue on going forward. Change is in the air and we have no choice. Transparency is critical. We still have many dealerships who are fighting these trends, who think that they don't have to do it or they're not going to get caught, or look, it's how I make my money. I'm going to do what I got to do. Let me tell you something. Look, I've worked in this business for a very, very long time, since the late 70s as a young F&I manager, my first job. And I will tell you that the things we did long ago and the things we are still doing in many stores today, and the three of us, that's Mimi, Ann, and myself, we hear stories all the time from consumers and others that we cannot believe is going on in dealerships, games that are played. If we don't change, I'll make a prediction today. I may not be around when this happens, but I'll make this prediction. If we don't change, the manufacturers are going to go to the federal government and ask to create a federal franchise law because they want the ability to sell direct in certain markets, because they, their words, not mine, will give a better buying experience. It's exactly what Tesla is saying. We'll give a better buying experience by selling direct, because look at all these complaints about car dealers, the lack of transparency, the way they pay, the games they play, the 5 hours it took me to buy a car when I did 11 hours of research before I even walked into the dealership, when they play games on pricing and so forth. We must make the changes. I'm happy to say Barry's going to start talking in a couple minutes here, and she's going to give you a lot of the comments that have been made, but we have to make changes. This isn't a matter of, come on, Don, let's go fight this thing. You got to stop this. It is not going to stop. The FTC under this administration has made the decision, and they're giving us time to get our act together. And thank goodness NADA has led the way, been very helpful, as well as our lawyers as well. So I hope that each of you will take this to heart, that you will walk the talk and make changes internally to make the buying process easier, smoother. Take care of our people, we'll take care of our customers, take care of our customers, we'll be good to our people. We will ultimately win the game if we take care of them. With that in mind, Barrie, you're on.
Good morning, everybody. That last screenshot, make sure you get that guidance. On March 13th, I'm just giving you a little background. March 13th, 97 letters were sent out to dealer groups around the country. Essentially, it covered the entire United States based on who did receive it. It was the warning shot. It had 6 points in the letters, and the biggest, most prominent had to do with price. And that's what this slide is. The total price advertised should essentially be the ceiling. It does not include in government fees, but it needs to include everything else and have no rebates. So when you have the largest price in bold, big font, that should be your ceiling price. Everyone that walks in there, that should be the price that they start at. You may go down from that price, but you cannot go up from that price. So that was the number one point in the FTC letter. So on March 13th, FTC essentially said, we don't care what any state code is, Virginia code on advertising. Our code trumps it because we are federal law. So that is essentially what the letters talked about. Pricing was a huge part of that. It's really sales practices that they were getting into in the rest of the points. But this slide summarizes the biggest key point, which changed the advertising through the entire nation that day. And not for about 3 weeks later did we truly get some true guidance from the FTC, which basically was federal law trumps state law. Therefore, you need to be in compliance with federal law. Now, in the state of Virginia, our advertising rules are kind of, they have guidance on it. So it used to be that, and I say used to because if you're filing Virginia law and allowing for the processing fee to be in the disclaimer, you're in compliance with Virginia law, but not in compliance with the FTC Act. For that reason, if you are in compliance with the FTC Act and putting your processing fee into the most prominent price, you are also in compliance with Virginia law. Virginia law does not conflict with federal law. So in the next slide, and you can go to that, I made up a fake ad, essentially, to help talk through the points on advertising because it gets wonky and it's a hard concept, but at the same time, very easy. If you have in the most prominent price your processing fee and you're not removing freight because that's not a government fee, you should be in compliance. It is pretty simple, but at the same time, there's a lot of nuances with it, and then it comes into third-party factors. So essentially, if your manufacturer requires MSRP, everyone understands that MSRP is not the dealer price. At the same time, you should have MSRP on there because you're trying to follow your manufacturer rules. You need to have your dealer price include your processing fee. Okay, so if your MSRP is $20,000, your processing fee is $895, your dealer price should be $20,895. The dealer discount in this ad should be available to every single person. It should not be a geographic discount. It should not have a rebate included. It is literally the amount you can take off for every single person, whether they're in California or down the street. And then the highlighted price underlined is that starting point. If someone comes in, meets 5 rebates that the manufacturer is providing, you can always go down from that price. The FTC is not going to be upset that you move from the price. What they are going to be, I should say, move down from the price. It's only if that price goes up. So those are the key factors. The ceiling that highlighted, bolded, really in large price needs to be the most prominent ceiling price of every consumer, and then go down from there. When,
Barry, if I
yeah,
can, if I can add, we've actually been trolling the internet a bit, looking at what some of our dealers have been doing ad wise. And one of the things that I have noticed, and maybe you have as well, Barry, is there are some dealers who have kept on disclaimers from sort of the old regime. So it's almost as if you're doing it right with the pricing and adding the processing fee, but there may be still language somewhere, on your website that says, pricing is, these prices may not be accurate. Some of these,
does that include dealer
rebates that are,
processing? Yeah.
they're not available to everybody, blah, blah, blah. Make sure you're not undermining your very good attempts to comply with an ad that looks like what we're showing on the screen here, and you're adding your processing fees and doing all that. And yet you've got some old disclaimer language on your website that may infer that you're not. So just make sure you're taking a look at that, because we have some places.
Great point, Ann. And a lot of that has to do with sometimes you put the new disclaimer in the box. So what I have learned from dealers is how hard it truly is to work with your vendors on the advertising. It is not easy between third parties, your own vendor. Each manufacturer has their own website vendor that you have to work with. So nothing is easy. And a lot of this in concept is easy to tell you, but it is a process and a hard process to implement when it comes to all the parties that you need to get on board with you. A lot of times the feed, you've had a general disclaimer that comes from a different feed. You need to make sure you're capturing, if you have 2 disclosures on your website, if you have 1 disclaimer, it may be all the way at the bottom. You may just need to get rid of it and figure out where it's feeding from. And so someone does need to do an audit of your pages. Absolutely, Ian. Okay, so this goes into those 6 points. So biggest thing we talked about, they've spoken, processing fees need to be in the advertised price. Freight is not a governmental fee, it needs to be in the advertised price. Rebates that are conditional, again, that's geographic, military, conquest, first-time buyer, college grad. You can advertise those. You just can't you cannot add them to that largest prominent price. So that fake ad that I made up, it had other conditional offers. You could put the amount so that someone can do the math, and you can, they could see that possibly they will receive more money off, but you cannot remove the $500 military discount from the $18,000 vehicle. MSRP, you can have it on the ad, but if you only have MSRP, you're not going to go up from that price. So you need to have a MSRP and then your dealer price, including the processing fee. Okay. MSRP became a big thing because I know a lot of luxury dealers require that to be the price of the vehicle. However, with the FTC trumps that, manufacturers the FTC was also very, has heard the grumblings from VADA, NADA, that manufacturers are requiring dealers to do one thing. They basically said everyone's going to be on the hook if we don't do it right? So MSRP, if you're required to advertise it, it can be advertised, but then you need to have your dealer price include your processing fee. Lease amounts. This became, so the guidance from the FTC focused on pricing. Everyone then became questioning, how do I advertise a lease? Essentially, if you are advertising, and I'm just going to throw out even numbers here, folks, because I am not great at math. If you're advertising $500 per month, and then all you say is $2,000 down, $500 per month with $2,000 down, and then in the disclaimer you have $1,500 acquisition fee plus your $800 processing fee, you are not in compliance with the FTC. It becomes a common sense. You need to look at your advertising. What does the consumer need to know they are paying that day to get that $500 down? That's what the FTC wants to see in the advertisement. So if you are advertising $500 per month, it needs to be the $2,000 down, the $1,500 acquisition fee, plus the $800 processing fee. So that needs to be in the advertisement. That full amount needs to be bold. So $500 per month with $4,300 out the door. Okay, that needs to be the advertisement. It can't be in the disclaimer anymore. In transit vehicles, FTC in one of their bullet points basically said you cannot advertise vehicles that are not on your lot. Well, this raised an alarming, this was the, eyes bulge, eyebrows up. Well, we have in transit. And transits are a lot of times pushed through the manufacturer. You had, and there was no true guidance from the FTC on in transits. During the Consumer Protection Bureau director, during his speech with Paul Mitri in April, he basically gave guidance about, in transit should only be on for a few days if advertised. Again, let's talk about reality. In some ways, the manufacturer pushes through the in transits when it's in the build process and it's not a few days. The biggest way to get to convey to the consumer that in transit is not on your vehicle, and there's not been true guidance on this yet. I think that NADA has asked for more guidance from the FTC on this, showing them that this is just a couple of days is not feasible, working with the manufacturers. So number one, talk to your manufacturer about the push throughs. No, and most likely, a lot of people have, and the manufacturers are giving them okay, we're working on it. Number two, make it as apparent as possible that vehicle is in transit, in the build process, not on the lot. Please call for availability, okay? If there is an estimated shipping date for that vehicle, you may want to put that in here. Estimated to arrive in August 2026. Please call for availability. Please call for any updates. If you would like to speak to us about down payments, please call us or stop in to talk about a down payment on this vehicle. Make that advertisement on in transit as consumer friendly as possible, that says it is not at my lot today. Do not stop at my dealership. That's the bottom line on in transits for right now. And basically training your employees on proper advertising. Each dealership does it differently. Your sales managers might be doing your pricing with your you may have an advertising person. They might be working directly with your vendors. The hardest part of all this advertising has come down to third-party vendors, which a lot of dealerships use, and a lot of people have had issues when it comes to how do I get them to advertise my disclaimer and things like that. Third parties, basically the FTC had said that who controls the advertisement will be on the hook for improper advertising. Third parties have a disclaimer on their website, and it's getting really nuanced into the legal part. They have a third party, they say that you're in charge of what is being advertised. At the same time, their platforms are dictating to you what exactly you can put on. So the number of people, you need to get it right. And if they're pushing back on you, you may have to pull back from their services. If not, try to get it as right as possible with the third parties using their platforms as possible. It has become a work in process. This has been going on for about 3 months. It is a change into the entire industry. And if you are having problems with that third party, you are not the only one. However, you want to make it as clear as possible that you need to get your pricing right. And a lot of times it's the push from VADA that helps with that, so that the third party in your website should be the same.
And Barrie, if I might, I actually got a call just yesterday from a dealer who had been contacted by a third party provider in this space, and they had been asked to confirm that they want to include the processing fee or include all their fees with their ad, but they were also given a choice not to, which I found fascinating. Unfortunate, but two things. One, they're doing that for their own protection because they want to be able to say, "Hey, the dealer told us to do it this way. We're not responsible." So they're not looking out for the dealer's interest with that. But two, back to Barry's point, make sure whoever in your dealership is checking that box that you know what they're doing and they know that they're supposed to be complying. So my biggest fear is that, the advertising person in your dealership's like, "Oh, look, I guess we can do it the old way." And, makes a poor selection that puts you on the hook. So just be aware there's just sort of lots of moving parts out there at the moment. And that's one of them.
Well, and Tanner has a great comment about used vehicles, about if it's in transit from the auction and out for recall, or a car should be retail ready or not on site. Agreed, Tanner. That is a big thing. The car should be retail ready to be on the site.
Yeah, and I would also note that the dealer board has had some guidance about vehicles and the location of vehicles when they're for sale. So I think that would go to the uh go to used cars as well as new. Again, what the FTC is getting at is they don't want someone to see an ad that says, this car here, show up at the store and it's not there. That's the quote harm they're trying to address. So in as much as your ad makes it very clear that it's in transit from wherever, it's going to help assuage that concern that the FTC has.
Great point, Ann, on the dealer board. Dealer board, if you have about 5 stores and you have one web page that has all the vehicles on it, that your vehicles need to say which location it's at, which would comply with the FTC. And then, as well as, I believe, Ann, when the vehicle was sold from the motor vehicle dealer board, and correct me if I'm wrong, motor vehicle dealer board requires that to be off the website within 3 to 4 days, something of that nature.
I think it's 5. I'll check on that, but yes, it is a number of days. So if you are, again, this is where the FTC and the Virginia regulations are very similar because, quite frankly, they're addressing the same problem, which is the idea that somebody can show up at a store and the vehicle isn't there. It's hundreds of miles away at another location.
All right. Next slide that we're going to get to on FTC goes into add-ons, and this is the selling practice portion of the bullet points of that letter. If you have any hard ads, that truck, you put a bed liner in the truck bed, it's already on the vehicle, that's got to be in the advertised price. If you have a product that if you require the consumer to buy, a VIP product that it comes on every vehicle. So you have your processing fee and a VIP, dealer's VIP product that includes certain things and it comes on every vehicle. You are charging it no matter what. It is not optional. That needs to be in the advertised price. Generally, pre-installed add-ons, a lot of people will say, well, these are all optional. Well, when the FTC looks at you, if you're unfortunately subject to an investigation, they will look at your penetration rate on optional. So you might be sitting in an office and no, in my dealership it's optional. Well, if the penetration rate is 65 to 85%, FTC is going to say, no, it's not optional. So I'm talking about, you do paint protection and you pre-install it, and whether or not the person we say it's optional. And we basically tell the consumer, well, you can get the warranty or not, and the warranty doesn't start. Well, if your penetration rate is like 75% on that, you have the rogue salespeople that are saying, oh, it's already installed in the car, that has to be added. Okay. So I really warn dealers about the optional products pre-installed prior to the consumer. And that's just to take care of yeah.
Let me chime in for a minute. Look, for all of us in the retail, we understand the game. And the game is, it really isn't optional when we preloaded this stuff on the cars. It isn't optional. What we want our people to do is to sell it to them as to why they should have it, even though it's installed. And so let's not kid ourselves. We cannot continue to make that mistake. The only way you can do that put stuff on a car is it must be in the selling price. Otherwise, be prepared to give it to them for free because you don't have to sell me the car, I guess, but I can refuse and your price is this. And the fact you put on there is not my problem. I'm paying that price. And the fact I get this stuff for free. So you're going to have to upsell rather than preload and then hope you can make it stick. And we all know this game goes on. It's been going on forever and ever and ever and ever. And we know it. And so we either got to stop it or you run the risk, if you will, of the customer saying, no, I'll pass. Well, take it off. I don't want it. I'm paying this price. And that has to include whatever comes with this car. End of story.
It goes back to the art of selling. Okay. Sales shouldn't be stuffing the consumer with products they don't want or need. It's the art of selling. Sell the product to the consumer so that when they walk in, they understand that that is the price they're getting. However, there are additional products that I'm a mom of 2 kids. I had my car within a week and I had permanent marker on my seats. You want to sell me the seat protection product to help me get that permanent marker out? Please do so. That's the art of selling. Recognizing I have 2 kids, I'm gonna have permanent marker on my seat within a week. Yeah, I want the seat protection. Okay, so what's the benefit to certain people understanding their lifestyle? I've had a car for 20 years. I obviously keep my car. The warranty on the car is only 2 years. What is the VP, what is the warranty? You can give me a 10-year warranty to extend the life of my car. Things of that nature. It goes back to the art of selling, but not stuffing the consumer. So again, front end add-ons, I highly suggest them not be pre-installed. Financing add-ons, there should be a menu of products. You should have a VPP program similar to the Fair Credit Lending Act program that the NADA has a fabulous program on VPP products. If you've not put it in your dealerships, you should do that by now. It's deviations on products, but the menus are key to these products. Understanding in the office what you're selling to people so that it's a benefit is also key. It's the sales practices, which is a big thing the FTCs were looking at. And it goes back to training and the art of selling. And then definitely audit your deal files. If you see certain things in deal files keep happening, that needs to be remedied immediately. And there should be a process to audit your deal files, whether it's a comply auto program, whether you have a compliance officer, but deal files should be audited regularly. And they should have everything in there. Pencils, you need to look at the pencils. You need to see what's happening on those pencils as well.
Thanks, Barry. I'm going to touch on some FTC advertising areas that are easy to overlook. First, truth in lending and truth in leasing. Your advertisements still need to comply with truth in lending and truth in leasing requirements. We raised this specifically because violations here are right in the text of your ads. So they're easy for regulators to spot, which makes them an easy entry point for an FTC investigation. So you should make sure your finance and compliance teams are reviewing your advertising for TILA and TILA compliance. Social media policies, this has come up quite a few times, and this is an area where there are really some opportunities to tighten things up. The bottom line here is that a social media post with an offer is considered an advertisement. So this includes posts made by individual employees on their personal accounts. So if you have a salesperson that's posting something on their personal Facebook or Instagram pages about a deal at your dealership and it doesn't comply with the advertising laws, your dealership can be held responsible for that. You should have a written social media policy that addresses this, but ideally anything related to the dealership should go through dealership hosted or dealership managed platforms where you will have the oversight and control over the information. Also, Barrie touched on this and Ann touched on this as well, third-party advertising sites. Your total advertised price must be consistent across every single platform. Whatever you show on your dealership website needs to match what appears on the third-party listing sites as well, because discrepancies between the sites are going to be a huge compliance risk. Then there's also some practical actions here. If you don't have updated addendum stickers, you should get them. Stickers on new vehicles need to display the total price, meaning the price of the vehicle plus the processing fee, which we've been talking about. And that needs to match what you're advertising. As Ann discussed earlier, if your sticker only shows MSRP and doesn't have the processing fee included, the FTC's position is that the MSRP would be your price and you wouldn't be able to charge the processing fee on top of that. Your buyer's order. This is also something that has confused a couple people. It's been tripping people up. So as you all know, the buyer's order has a line for the vehicle price and a separate line for the processing fee. Under the FTC's framework, the vehicle price on the buyer's order should actually be less than the total advertised price on your website, because the total advertised price includes the processing fee, which then will get broken out separately on the buyer's order. So putting it more simply, the vehicle price on the buyer's order plus the processing fee will equal the advertised total price. Everyone should train their staff on this because it's been a common source of confusion that we've been hearing over the past couple weeks. And then also when talking prices with customers, you need to train your sales team, both new and used, on what they need to say when a customer calls asking about the price. So when a customer calls and asks for the out the door price, the answer that your salespeople must give must include the processing fee and freight. There cannot be surprises later in the deal. This is going to be a training issue, and it should be part of regular onboarding and ongoing coaching going forward.
And with that, I'm just going to put up on the screen a few of the frequently asked questions that we've put together. Now, we are expecting some more guidance in perhaps in the form of some additional frequently asked questions from the FTC, but these are ones we've sort of come up with. If you have additional questions on that web page that was linked with the QR code earlier in the presentation, there's a place to send those questions. You can send them to me directly. You can call me, whatever you want to do. Call Mimi or I and ask specific questions that you may have with compliance. I know that one of the questions we got in the chat earlier is if all this is going to be available after the session. Absolutely. What we'll do is we'll take this presentation and this recording and make it available in total, but we also try to break out some pieces. So Mimi was just talking about training. We'll have this segment on the FTC as a standalone segment that you could use to train your folks, for instance. So we'll make sure and provide those resources for you. We had talked a little bit before about the manufacturer doesn't allow advertising above MSRP. You know, again, you gotta include your processing fee. We've had a lot of questions about incentives that require the customer to finance. Technically, no, you cannot reduce the price of the vehicle by those types of incentives. That's problematic. We know they are very, very complicated incentive schemes these days that manufacturers have. And again, any condition that means that every person that walks into your dealership doesn't necessarily qualify, that's something you can no longer subtract from your price, full stop. It's really that simple and that complicated all at one time. Again, so many different, we had a dealer sent us incentives. I've never seen such a list of gobbledygook in my life. So I feel the strain that you all are under as far as how to advertise fully to customers what may be available to them as far as a way to reduce the cost of their new vehicle. But if there's any conditionality to it at all, it cannot be subtracted from the price. Can you still use call for price? Yes. There's certainly that's certainly still available to you. The problem becomes if your ad includes the MSRP, that's going to be your ceiling. You won't be able to add your processing fee. So just be careful when you are listing call for price. If your ads are pulling the MSRP from somewhere, you need to be aware of that. And then just also make sure you're training your folks how best to respond to those call for price advertisements. Again, this is one we get when folks are looking at their competitors' ads. If an incentive is available to all customers, or if it's something you're providing to all customers for free or whatever, do I have to separately list it, or can I add it to the dealer discount? Your dealer discount can be made up of anything that's available to everybody. So if you don't want to have, 5 lines in your ad, but this amount is what every person can get off of MSRP on this car, then you can group all that together. That's not a problem. And again, third-party sites are very active in this field, and just want to make sure you're paying attention to all of that. And go ahead, Don.
And let me make a quick comment. I've gotten the question a lot about enforcement, and unfortunately, enforcement is what is going to cause many of us to get into compliance. The fear of enforcement, what will take place, what will not take place. And some have said, well, I'm in a more remote location, or I'm a single point, who the hell's coming after me? The issue is this: look, your competitors will see what you're doing, and that will be reported, I'm sure, to many folks. But I will tell you, I do know nationwide, factually, there is a movement afoot for the AGs, the attorneys generals nationwide, to get more engaged and to help the FTC sort of facilitate the enforcement in their states. And you're going to see laws change even in our state as it complies, to make sure we are in compliance with the FTC. And so that is coming. And so the states are going to seek more enforcement. The unfortunate part is this: they recognize, as an industry, we're 103, 105 years old, that we've kind of always done things the same way forever. And that is a true statement. And that the only way they're going to get our attention is enforcement. And we've had some dealers who've had some enforcement in Virginia. It is not pleasant. It is expensive. It is controlling for life in many cases, or for many, many years by the FTC. So at the end of the day, there will be enforcement, and dealers will turn in other dealers for sure. But watch the consumer protection folks in the Commonwealth of Virginia get more engaged in this arena for sure. And so that enforcement will take place. Let's do this. Let's get in compliance without having the enforcement come down our throat and do really bad stuff to us. Get in compliance, pick up the phone and call your neighbor and say, hey, neighbor, why the hell are you doing what you're doing? Or call me and I'll call them and say, why the hell are you doing what you're doing? And I'm happy to do that. So feel free to do that, to let me know. Look, I don't have the ability to enforce. I don't want to enforce, but I got a friendship and a relationship with most dealers. And I don't mind saying, why the hell are you doing that, when you know damn well you can't do that circa 2026 or 27 or 28, whatever it may be.
And lastly, our partners at Comply Auto are just going leaps and bounds in lots of areas. But one of the things that they have is an automated ad compliance that really takes into account all of these things. They'll scan everything for you. They are really on the cutting edge of all of this, and they've got a great offer through June 10th for $75 a month per rooftop. So it is worth looking at your ads and having a company that is as learned and as professional as Comply Auto looking at your ads. This is just an area where there's so much risk, and it's getting harder and harder to do these things completely yourself. So take a look at this Comply Auto program that they've got. It's really worth exploring, and reach out to them quickly so that you can take advantage of this great offer they have for dealers.
And I'd just like to add, if you haven't seen it in person, it's a great, I would contact them just to watch what it does. It's really cool. When it scans your ads, it picks up really nuanced laws that people forget in their disclaimers. For example, each disclaimer should have a time limitation on what the price is. So you should have in your disclaimer something that says, you know, prices go through the end of the business day. That is something nuanced that most people don't have actually in their disclaimer. So this program is really cool, and it will guide you as to what you're missing and under Virginia and federal law.
And very along that note, the majority of the compiled, and certainly the founders and the people who run it, and the executive staff, you all, are all lawyers, most of which came out of dealership organizations. These are not green peas. These are not people sort of learning our business, saw a niche, and are filling it. These are people who have spent their careers working directly in our business and with dealers. And so these are the best of the best, which is why we have a relationship with them.
And lastly, I'll just mention a couple of things on some other federal issues. We wanted to focus most prominently on the FTC, as you can imagine, but just a little plug for a couple of other things. I know Barrie mentioned fair lending the other, in some of her previous comments. The NADA has a great fair lending policy, sample policy. You should be using that and enforcing it. We've spoken a lot about protection products today. NADA has a great guide on this. We have a new partner in Brown & Brown for F&I. They are an international company, one of the world's largest, and they have a complete and dedicated auto division, and they can certainly help with your needs in that area as well. Lastly, we just want to mention safeguards rule compliance. This is a big area with consumer data and all of those things. This is an area very clearly where it's almost impossible for you to do this yourself now. You ought to be reaching out to Comply Auto on this issue as well for all the different testing that you need to be doing on your systems annually. They can help with all of this. Again, it's one of those areas where, unfortunately, they're treating every dealership like it is multinational banking institution, and so you're under the same rules, and it's just very difficult to do it internally yourself. Give Comply Auto a call for their privacy program that they've got in place. And with that, we're going to turn to some franchise issues, and I'm going to turn it back over to Don.
Real quickly, look, as I talked about earlier, the dealer day on the Hill, we talked about our PAC fund. Let me tell you something. We're dealing still right now with VW and Scout. Scout wants to sell direct. The argument is that we can give a better buying experience, a better price, a better this, a better that, yada, yada, and so forth. Understand clearly that this movement is not just going to be VW. There are other manufacturers that are watching who deep down inside want to do the same. In other words, they want to pick markets where it makes sense for them to sell direct. Not in every market. They'll let you, take care of that responsibility and that expense, but they want to go in the markets that are prime for them and their products. We have got to be unified as a team. We've got to be involved as an association because the franchise laws continue to be under attack. I made a lot of comments earlier in the year about the Alliance of Automotive Manufacturers and last year as well. This is their VADA, if you will, for all the manufacturers. These individuals say things that are categorically untrue, very offensive about our industry and what we're doing and not doing. Wake up, pay attention. If you care about this business and plan on being on it for the next 5, 10, 15, 20, 25 years, you damn well need to be involved. You've got to participate in the things that we do because I'm telling you, folks, this stuff is alive and they're moving with great pace to take control of the franchise system. They want to take it out of our hands. Don, come on, give me a break. This isn't so. It's exactly what they do in Europe. It's exactly what they do in the Far East. This is something they're very familiar with and they want to do. We can stop them if we unify as a body in Virginia and nationwide. We will prevail, but we've got to give customers a better buying experience and be aware of what's going on with these manufacturers. These are not innocent actions. These are long-term actions to change your system. Even an Amazon selling direct is a long-term action to change your way of life. It may be good right now today, but long-term wise, these are not positive. Please, please, please pay attention, support VADA. This is why we exist. And long after I'm gone, there'll be others doing the same thing, saying the same thing. This is why we are here. get involved in your trade association. Barry?
I think we put this on every presentation, but it's a reiteration of your rights. Franchise laws are not self-enforcing, okay? You actually have to enforce them. OEMs are going to put whatever they want to put in front of you, hoping you sign it, do not read it, just do whatever they say. Virginia has a catch-all statute that basically says manufacturers, when they send, let's say they're sending, there was one manufacturer that sent a bunch of documents about a year ago, changing right of first refusal in their franchise agreement, and other things. Right of first refusal was completely against our state law. They never sent it to the commissioner. So when they send it out to all the dealers and say, oh, please sign this as this new addendum to your franchise agreement, well, they have a requirement that they actually send it to our commissioner to have it looked at and to see if it conflicts with any state laws. Well, it was completely conflicting. Some dealers just signed it. Other dealers brought it to VADA's attention, and VADA did write a letter to the manufacturer as well as the commissioner. And the commissioner basically was very receptive to it and says, you need to submit your package to the commissioner, and this conflicts with the laws. So be careful what you're signing. One of the big things that I see quite often are the addendum. Um, is the addendum that goes towards a facility. Let's say you're buying a dealership and they're going to give you 3 years for facility upgrade, or not. They tell you, hey, your dealership, your DSSA is up and it's time to re-sign, and here's the addendum. Well, number one, there's no timeline under DSSA. Under Virginia law, your DSSA is only up when they actually do file a termination against you. Okay, so there's no timeline under DSSA. And that's your dealer sales and service agreement. So there's no need to sign documents that re-ups your dealer sales and service agreement and or addendum if it's in unfavorable terms. If they want you to redo the facility, you need to look at those terms. Can you get it done in 2 years? The entire build process. You have a zoning board that's going to require you to dedicate a road and go through a bunch of hearings. I mean, that may be a year process. I mean, really look at what you are signing. And so we do offer you a checklist that my firm has crafted over the years. My dad started these checklists years ago. We have updated them for a number of years. And when looking at what the factory is requiring you to sign, it just go through the checklist and say, okay, no, this is not correct. It conflicts with this. Know your rights.
Thanks, Barry. Now we're going to go into some legislative issues some bills that we passed last year. So first, these changes are already in place, but we want to make sure that you are all familiar with it. First, the big warranty bill that we passed last year removed the reasonable qualifier from how manufacturers calculate the reimbursement rate for warranty work. So as you all know, previously manufacturers could argue that a labor rate was unreasonable by pointing to lower rates at other dealerships. The argument's now gone, and the statutory calculation now controls. Manufacturers cannot use comparisons to other dealers to bring the rate down. Second, the law now guarantees that your technicians are compensated for the time they spend waiting for or communicating with the manufacturer for technical assistance on warranty or recall repairs. Third, manufacturers can no longer arbitrarily reduce the price of a part used in a recall or similar repair. The price of the part is now set at the highest price charged in the last 12 months. This closes a loophole that the manufacturers were using to reduce reimbursement of recall repairs by manipulating the part's price.
Even if they change the number on the part, if it's the same part, they're required to pay that highest price. That's the game. They'll change the part number and say, no, this is a different part. No, it isn't. It's exactly the part that they had previous to the recall that you were doing.
Additionally, on rental reimbursement, if you provide a customer with a rental vehicle during a warranty repair, you can now request reimbursement from the manufacturer within 30 days of paying for the rental. So you no longer have to wait for the underlying warranty claim to be paid. The law also clarified that when a manufacturer required a dealer to provide a rental, the manufacturer must provide reimbursement for that rental. There can be no excuses or exceptions to pay based on the type of vehicle rented. And finally, dealers can also now return unused recall parts. I also wanted to touch on over-the-air software upgrades. They're increasingly important and relevant topic. We actually already have a Virginia code section on this. Under the code, manufacturers are permitted to sell certain OTA upgrades directly to consumers, but they're required to give dealers a written disclosure for each vehicle describing what features or functions can be initiated, updated, or changed remotely, and what the charge to the customer will be. The other important piece here, if a customer needs assistance at your dealership related to an OTA upgrade or OTA related repair, you are entitled to compensation at your retail labor rate. So as you all know, as vehicles become more software driven, the area is only going to grow in importance. So you need to make sure that your service advisors are aware of this.
And I know we've talked a lot over the years about, how your manufacturer measures your performance. So make sure that you understand your rights under Virginia law when your manufacturer is coming to you and saying you're not sales effective or you're not, your CSI is too low. There are real protections in our code to make sure that one, you receive any incentive monies that you're entitled to, despite some claim by the manufacturer that there's some deficiency in your performance. Make sure that you're prepared to challenge those. Obviously, the one that we see most likely as a sort of as something that will lead to a lot of these sort of performance struggles is how they're defining your market area. That can certainly affect your sales effectiveness. And so these are all building blocks that sort of work with each other to give the manufacturers the feeling that they can challenge what you're doing and wrest some concessions from you about your performance. But you can challenge all these things. You can challenge your market area. Is it a place where the traffic patterns are different than what the new MBAs at urban sciences tell the manufacturer? Oh yeah, they should be able to sell into that area, but different because you live there. So make sure that the big message with all of these franchise matters is that you need to make sure that you know what your rights are so that you can challenge those manufacturer claims when they come down the pike. Don't leave these things unanswered. Make sure that you're responding to anything the manufacturer is claiming about your dealership and its performance.
This touches on succession. You need to have a succession. You need to have a succession plan now. It shouldn't be, your family shouldn't know, it shouldn't be up in arms or scared should something happen to you. What is your succession plan? A lot of dealers have trust nowadays. The dealerships are owned by the trust. The trust has to be given to the manufacturer. However, there should be a succession plan so that if something does happen to you, your family is not fighting with them through our code section. They're not fighting with them in general. It does not drop the price or, this is a huge asset of your family, of yours. If there is no succession plan, it could lead to issues for your family and possibly issues with the value of your dealership. Make sure you have a succession plan right now. Next is right of first refusal. This is one of the biggest questions when anyone is selling and or buying dealerships. What is the right of first refusal law in the state of Virginia? In 2016, the law was changed. We've had this in a lot of presentations, but it's understanding what is the law and what are the rights, especially if you're buying. Right of first refusal is manufacturers cannot right of first refusal if it's a family member or a manager with 5 or more years, or in general, unless there is a minority program where the minority dealer will be the dealer and essentially own at least 51% of the dealership. The key to this is that the manufacturer has a minority program and that the buyer is a minority that will own 51%. This has been, there's not a ton of right of first refusal in the state of Virginia. You need to understand your rights. The manufacturers have tried to send letters that say, we have a blanket franchise, our franchise agreement says we can write a first refusal to anyone. No, we also have it's 45 days. A couple years ago, we changed the buy-sell statute that it's very limited on denial rights. It also has a 60-day window that they have to deny. Well, there's now a protocol. Basically, when they receive the APA, there should be a notice with the buy-sell as to who the buyer is, their financial ability, and their qualifications. And that's the notice requirement underneath the buy-sell statute. The right of first refusal statute now is as soon as that notice, it's within 45 days. So it's a short window. Make sure you understand your rights. It is a limited right in the state of Virginia.